Good morning, good afternoon, and good evening. Welcome to our international webinar. My name is Milton Lucídio Leão Barcellos, and I'm pleased to welcome you all, and I will be with you during the beginning of this morning, afternoon, or evening, depending where you are based right now. This is a special webinar that will open a series of the total of 3 international webinars based on the present and the future of intellectual property rights, with the qualified view of remarkable academic experts from China, Europe, and the United States of America. We are really happy to have registrations from different scholars, entrepreneurs, IP practitioners, IP professors, and IP students and IP researchers from Brazil and many different countries from the America, Europe, and Asia. Up to yesterday, we had more than 280 registrations through the LinkedIn platform, and additional more than 50 registrations through the Eventbrite platform. Thank you all again for joining us for this inspiring lecture. That makes all of us really pleased with the interest about the subject, and it must be said, the recognition of the well-known Professor Dr. Xiang Yu as the remarkable lecturer of this webinar. An important and rare opportunity to learn from a remarkable IP scholar from China. Let me introduce to you our lecturer. Professor Dr. Yu is a full professor at the School of Management and the director of the Sino European Institute for Intellectual Property of Guangzhou University of Science and Technology, HUST. I had the pleasure to visit Professor Yu at the university. He is also the director of the Chinese-German Institute for Intellectual Property at the School of Management of HUST in Wuhan, China. Since March 2017, Professor Yu also holds the post of the Vice President for International Cooperation of Hubei Normal University. His main research fields include intellectual property and international trade, patent strategy and technological innovation, licensing and technology transfer. He is the director of the Chinese IP team for the US-China CERC project and the director of the Chinese IP team for the China-European Union CCS project. As a guest professor or speaker, he gives lectures and presentations regularly in Germany, France, Switzerland, and many other countries. Professor Yu was granted to be a German Alexander von Humboldt Research Fellow in 2004 and was granted to be a JSPS, Japan Society for the Promotion of Science, Research Fellow in 2006 and 2007. He is a member of Academia Europaea since 2020, member of the IP Experts Group of China, visiting professor or lecture professor in many universities in China and other countries. He is also a member of the Standing Committee of the People's Congress of Hubei Province in China. Today's Professor Yu's subject is based on the challenges of artificial intelligence to patent law and copyright law and countermeasures. Our honorable lecturer will address key issues involving artificial intelligence and IP rights, such as inventorship and authorship, new developments, the increasing China leadership in the AI technologies, and how the Chinese patent law and copyright law is dealing with such challenges. As we all know, AI is more and more part of different creations, products, systems, processes, and services. AI is basically formed by a combination of an algorithm, big data, and machine learning technologies applied to different technological fields. For example, when we watch Netflix, the AI will learn about my choices of films and shows in order to recommend new films and shows aligned with my previous profile, as well as will help Netflix to form a database about users' profiles, which can match with future movies and shows to be created by Netflix. I would like to say thanks to my colleague, patent engineer and patent attorney, Ms. Kelly Janowski, behind the scene, and in order to everything works smoothly during this webinar. And before giving the floor to Professor Yu, I have some quick organization notes. This webinar is being recorded and will be available in a few days in our YouTube channel. The questions and answers, the Q&A, will be available through the specific chat that you all can see in your screen. Please feel free to address your questions to Professor Yu, identify yourself, and addressing the specific question through the Q&A chat. After the Professor Yu presentation, we will have a specific time designated to the Q&A. Professor Yu, it's my great pleasure to receive you here with us, and the floor is yours.
Thank you. Thank you. So, good evening, good morning, good afternoon, my dear ladies and gentlemen from all over the world. And it's my great pleasure to have this chance to be invited by my good friend, Milton, an excellent professor and a lawyer in Brazil. So today, I would like to talk about the challenges of artificial intelligence to patent law and copyright law and possible countermeasures from the perspective of the Chinese scholar. Yeah, from my perspective. So certainly, the technology of artificial intelligence are always go ahead. The situation is always changed. So from today's lecture or presentation, I would like to talk about four parts. One is the AI and its development. The second part is the challenges of AI to patent law. And the third part is a little bit challenges of AI to copyright law. Because of the time limitation, maybe this part will be relatively simple. And then finally, we discuss some possible solutions. And your input will be warmly welcome. So, as you know, AI now is a very important technology and used in many different ways in our daily life and the manufacture industry and for the medical use, including especially in such COVID-19 epidemic situation, including collect the information of different private and also try to invent some vaccine and diagnose method to treat or prevent COVID-19. So which kind of invention belongs to technical solution should be or could be protected by patent? Which kind of invention or method cannot or should not protected by patent law are still in discussion. We can say if we use AI technology suitably, so AI is the angel of master prize. However, in contrary, if mankind misuse AI technology, that should be the hand of devils. So we can think about the fairness and many other aspects, how to make balance. Actually, the basic concepts of AI, as you know, many of our friends are already familiar with that. So to make things more easy, more simple, more exact, and the research objective explore the essence of intelligence and develop a machine with human-like intelligence. Research content include theories, methods, technologies, and application systems that can simulate and extend human intelligence. So the AI actually has the ability for seeing, listening, saying, moving, thinking, especially deep learning. About artificial intelligence, it has already mentioned in a conference in 1956 at Dartmouth College by Professor John McCarthy. Okay. However, the AI technology was quickly developed only in recent 10 years, just because other relative technology are gradually developed. So AI itself could be used suitably. From the patent application number, we can also see such kind of situation. Just in recent China, the AI development has already began in early 1980s. And in recent years, especially in 2016, combined with the Made in China 2025, the Chinese government has also published Internet plus AI 3-year action plan. This plan was also known by many foreign academics. For example, last year in the US, we have the 38th A-Trip conference. Our US colleagues know that and explain that to the audience, also discussed with me. And the government also established a so-called AI 2.0 by 2030 to promote China's high technology and industry development. In this promotion plan, AI should be highly focused. So some examples of AI application. For example, in 2016 and 2017, AI called AlphaGo successfully defeated 2 mankind championship, Li Shishi and Ke Jie, become the first AI program to defeat the world champion of Go. Also in October 2007, Saudi Arabia awarded the robot Sophia citizenship produced by Hansen Robotics. That is the first robot who acquired citizenship in the history. And you can also saw so many different kinds of companies and industry area and also service industry area use widely the AI technologies. Some of them are international trademark, and also many of them belongs to the Chinese companies. So relevant laws and regulations need to be established because of the very quick development and applications of AI technologies. There are also many problems we need to think about and do different kind of countermeasure and treatment. For example, in September 2007, the UNICRI established the first United Nations Center for Artificial Intelligence and Robotics in Hague. On April 10, 2018, 25 European countries signed a Declaration of Cooperation on AI. On April 8 last year, the European Commission presented ethics guidelines for artificial intelligence and require all use of AI technology should fulfill the requirement of ethics and the fairness, safety, and so on. So now let's have a quick look about the challenge of AI to the patent system. In this part, mainly we will discuss three key issues. Which kind of AI-related technology or technical solution could be patented? That means the problem of patentability. And the second issue is ownership. If one or more technical solution could be patented, who will be the patentee? And thirdly, it's about infringement liability, and even include how can judge activity should be infringement or not. So the first issue is patentability. It is still necessary to encourage AI-related innovations at the present weak AI stage. So in this presentation, I try to divide the AI stage into two different parts. Nowadays, in this stage, it's just a weak AI because the AI invention and AI-related activities or innovation activities still need the support or the participant of mankind. So in the future, maybe 10 years ago or 20 years ago, so when AI can totally independent to do some innovation or invention, and without any participant of mankind, so that time should be the strong AI stage. So in this stage, I think we still encourage AI-related invention by issue patent protection to AI-created inventions. So now there are some relative questions. So which kind of topic should be protected? Which kind of invention should not be protected? So let's use the method of exclusion. So it means exclude those technology belongs to the hand of the devourer. For example, killer robots. The killer robots is very harmful to the safety, to the peace of the world. So invention contrary to public order, for example, killer robots should to be excluded by the patent law to be the patentable topic, patentable subject matter. And second, if some so-called invention, just the fast algorithm or game rules based on data precision and enhancement algorithm, those do not belong technical solution, therefore could not be protected by the patent law. So in those kind of content belongs to the exception content by, for example, the Chinese patent law, Article 25. So for the invention contrary to public order, the exclusion belongs to the content, for example, by the Chinese patent law, Article 5. So third, some inventions with unpredictability and potential irreversibility, for example, all AI-related technologies combined with algorithms of machine bias or black box. So you cannot predict what will be happened. So it is maybe very dangerous. Such kind of technical solution should be excluded from the patentability content. However, yes, it is very difficult to determine which kind of technology belongs to the black box or machine bias. It is still need to discussion in detail. So now in the patent law area, the first challenge is how to judge a technical or invention created by AI belongs to algorithm. Which kind of them belongs to technical solution? So there are so many different kind of example. Fingerprint identification system and used in the mobile phone serial, and unmanaged system for example, the auto driving, unmanned system, or AlphaGo robo advisor. So, but in recent years, there are some invention created by AI is really excellent. For example, in 2013, Ruskin developed Eva. Okay, that is an AI robot with the advantages of self-learning, this kind of ability, and automatic drug identification, which the Eva found an anti-cancer compounds. So by many more than 5,000 time experiment, finally Eva, this AI robotic, found an anti-cancer compounds. It's very useful for medical production. So that is really an invention, should be protected by patent law. So now the challenge 2 is, if the AI created invention should be protected by patent law, so whether we need some special criteria of novelty, creativity, and practicability for AI created invention, whether such kind of standards should be different from the standard of human being created inventions. So that is the second challenge. So for novelty, for example, if the patent law regulate more stricter standard for the AI created invention, so maybe some breakthrough technology solution could lose their patentability. If the standard is too low, so could lead a lot of junk patents. Also not so good. For creativity, who will be the ordinary skilled person in the art in the current patent law? Whether such kind of ordinary skilled person in the art should also include other AIs. So how to judge the creativity? And who should be the traditional ordinary skilled person in the art? That is also questionable. And then practicability. So how can judge the beneficial by the inventions, creativities created by AI? Because improper use of the invention could be a threat to human survival. And also, how can judge the so-called repeatability? Challenge 3 is ownership. It's a very important issue. So if finally we decide an AI created invention is patentable, should be protected by patent law. Now, who will be the patentee? AI itself, or who created the AI itself, or the owner or user of the AI? Who will be the patentee? So you can have a think, and finally we can do some discussion. Does the patent right belong to AI itself? If you choose this solution, it will be difficult to achieve the legislative purpose and the purpose of the patent law. Because, for example, in Chinese Patent Law Article 1, it was clearly regulated that protect the patentee or grant the patent right to the patentee is just a method to encourage continued invention. Finally, to rise the benefit of public, to promote the technological progress of the whole society. So AI itself actually do not need such kind of encouragement. So it seems the patent right granted to the AI itself will not be a good solution. So now another two choice, whether the patent right belongs to the inventor or producer of the AI robot. Maybe some of you will think, yes, because the AI itself was invented by the former technical man. So who invent or produce the AI? But actually, the invention or technical solution created by the AI robot in many cases was the result to finishing the task just by the owner or the user of the AI. So it seems it is also not a good solution. So the third possibility, patent rights belongs to programmers who manipulate the AI. Maybe we can see that is a non-explorer invention. But programmers may not have made creative contributions to the invention created mainly by AI itself. So maybe such kind of invention will belong to the owner of the AI. We can think maybe that is the employee invention, because the AI finished the invention or technical solution for the entity, for a group, for a company. So now the company should be the company which own or use the AI should be the patentee. That could be a better solution. So we can continue discussion. And then gradually we go to the challenge 4 and 5 in the part of infringement liability of AI inventions. Because the patent infringement of AI is very complicated. There are many participants in a whole technical method or technical solution. Some of them just use one part. Another part was used by other entity or other person. So the characteristics of patent infringement of AI include multi-stage implementation, indiscoverable, and multi agent implementation. So the challenge 4 is how to identify infringement. And plus challenge 5, how to determine infringement liability and responsibility to investigate. Responsibility to investigate. So whether the infringer should be AI itself, or its former inventor, or its owner. Okay. For example, in the cloud computing system, such kind of technical solution, there are at least 5 different parts. The platform providers, system integrators, service providers, application developers, and users. Each part only implement a part of the whole technical solution, means a part of the patented technical solution or technical feature, especially in the claims. So it seems each part did not infringe the whole patented technology. So only the different part together, they implemented all knowledge solution or technical features. So in this situation, means the question is, if there is no direct infringement, whether so-called
Professor Yu, we cannot hear you. I think we had some technical issue related to your voice. I don't know why. We can see you, but we cannot hear you. Let me see. Just a minute. Kelly, can you hear Professor Yu?
Oh. No, I can't. It's yeah.
Still.
Try. Let me try again to change the.
Okay.
The person.
Just a minute, Professor Yu. We are trying to see what is happening, because we can see you, but we cannot hear you right now. It's just.
Professor Yu, maybe try it without your headphones.
Now, can you hear me?
Yes, yeah. Perfectly.
Okay.
Perfectly. So, okay. So let's get back. Sorry about that, but I don't know what happens.
Okay. Okay. Now continue our talk. So, for example, in the cloud computing system, each part only use part of the whole technology. So it seems without direct infringement. But in this situation, whether indirect infringement would happen. So that is our question. So in the CAFC from 2007, at that time, the judgment was no infringement, because the judge thought the direct infringement is the precondition of indirect infringement. But gradually, finally, especially in 2015, in the case of Limelite, so the judge has to make the decision. Although there is no direct infringement, the indirect infringement still happened. So because it is a special AI environment. So because of time reason, I will not introduce such kind of cases in detail, but you can check the case and read it. So now the third part is about challenges of AI to the copyright system. So in copyright law, there are similar questions. There are also different questions. For example, which kind of work finished by or created by AI could be copyrightable? The AI created work belongs to human users or human ownership. And second, again, ownership. If the AI created works could be copyrightable, so who will be the ownership? Who will be the copywriter? So AI itself, the person or his employer who created the AI, or the owner of the AI. Third, about the infringement determination. How to suitably delimit copyright infringement. So mainly such kind of three questions. So let's go on. So which kind of works belongs to the work could be protected by copyright law? At such weak AI stage, the so-called AI-produced work are actually finished by AI cooperated with mankind, because the work generation software designed for a specific purpose were finished by mankind. So finally, the AI based on the software designed by the specific purpose finished by a person continue to draft, for example, a picture or a literature work. Okay, the work should be copyrightable in case there is originality and replicability with the originality and replicability. But it is also a challenge to judge whether it fulfills this kind of precondition. So let's have a look. The Van Gogh star style was used in other photos. So this is a current picture. That is the original work of Van Gogh. And then combine these two belongs to a new work. So whether this kind of new work can protected by copyright law, for example. So if some of them could be protected or should be protected by copyright law, who will be the owner? Who will be the owner of the copyright? There are so many different kind of examples. For example, this deep dream is created by Google AI and also already sold in a very higher price, $8,000 US. Now, this work finished by AI Deep Dream. And there is also a so-called Microsoft Xiaobin. There is a work, the name is Sunshine Lost Glass Window. Oh, this is a Chinese book. The name is Sunshine Lost Glass Window. But this is Chinese. In Chinese voice is 阳光失去了玻璃窗. But it's difficult to understand for you. So whether such kind of work should be protected by nowadays copyright? If yes, who will be the ownership? Will be the copywriter? Especially who will be the author? There are different kinds of content of copyright. Who will be the author? Now here is the AI. So the name of the AI printed on the book as the author. So maybe possible solution about ownership and protection. Firstly, AI could have the right of authorship. So actually, it was printed by the mankind on the book to use the AI's name as the author. Okay, especially should have in the future of strong AI stage. Because finally, I will suggest in the future strong AI stage, the so-called order should include not only mankind, but also AI. So other copyrights should belong to the producer or owner of the AI. So that means the property right belongs to the producer or owner of the AI, but the authorship belongs to AI itself. Second, the AI works should be registered for clear determining ownership, because in the future, gradually more and more AI created works was published. So a huge number. How to recognize and determine the ownership? We suggest that AI finished works or created works should be registered for clear determining ownership. And the protection period of AI produced work should be 50 years, because the AI has the so-called age limitation. Okay, AI can always exist. So about the infringement and liability of AI works. Replication and limitation are very easy, especially the exact replication by AI is very easy. So maybe we need some new standard of originality. And liability belongs to copyright owner, certainly, because the right and liability should belong to the same one. So again, Van Gogh's Star Style is a typical case. So gradually we go into the final parts. Possible solutions to AI created inventions or works. So we discuss 4 points. Whether the AI created inventions or works should belongs to public property, means open for everyone, so everyone can use it. That is one possibility. But whether it is suitable in nowadays weak AI stage or in the future strong AI stage. Second, whether new neighboring rights for AI created works are needed for the copyright law. Third, is there any new generis right will be needed for AI-created inventions or works. 4. Change the regulations about primary rights in patent law and copyright law. It is necessary or not? So we discuss these 4 topics in this part. Firstly, should we put all the AI-created inventions and works into the public area? Means no protection. Okay, everyone can use it. But I think, at least in current AI stage, public property should not be a good solution for AI-created inventions as well as works. Otherwise, mankind or other AI will limitate them lawfully. Everyone can use it. Okay, it is not good for encourage innovation and creation in the AI-related technical field. Not so good. So in nowadays stage, we still need to encourage the inventors to do invention, combine the AI technologies, including in the current COVID-19 situation. We need to encourage the inventors to do invention, to use more good technical solution to treat, to prevent the COVID-19. So we need such kind of innovation. We need to promote them by granting patent right and copyright. But in the future, strong AI stage, this could be a possible solution. Means because at that time, AI created invention by themselves, almost without any support and participant by mankind. So there are more and more inventions, more and more works. At that time, maybe those belongs to the public property. Could be a good solution. Second, whether some new neighboring rights for AI-created works are needed or is needed. For example, there are data processor rights. In the whole process of AI-related invention is implementation, data is a key issue, key element. So in just now we talk about the cloud calculate. In that process, data in different stage has different kind of data. So put into the whole process. Whether we need to grant so-called data processor right to be enjoyed by the owner of the right to use the program or equipment that generates the data. So that could be a new neighboring rights. Third, maybe some new kind of sui generis right is needed. So at least in the weak AI stage, up to now, it seems still not necessary to increase new sui generis right for AI created inventions or works. Not needed. But researchers need to do continually for considering possible sui generis right in the future strong AI stage. We're just still in the research project to do continual research. And finally, whether it is needed to change the regulations about primary rights in nowadays current patent law and copyright law. So in this weak AI stage, for patent law, in the restrictive provisions, like in the Chinese Patent Law Article 5, for patentability, it is already necessary to increase safety and aesthetic regulations for AI-related technologies, I think. Because the AI technologies, as we talked about in the beginning stage, if we use it suitably, it is a good thing. It's a very useful support. However, when someone misuses the AI-related technology, so we are very harmful to our safety and ethics. So if now we just use the so-called right balance, benefit balance principle in the patent law regulation as well as copyright law regulations, is already not enough. So safety and the ethics principle should be increased in patent law. And in the future strong AI stage, for copyright law, it would be considerate to change the regulation of works, to extend the qualification of subject, means the qualification of author, from only mankind to also AI inclusive. So maybe in the future strong AI stage, AI should have the qualification of author. So I think up to now, I talk about this several part a little bit quick, but maybe we can close here and to do some more discussion. Okay, Milton, thank you very much. Thank you very much for your attention.
Thank you very much, Professor. Thank you very much, Professor Yu. It was a wonderful speech, and I really think that we have a lot of things to discuss. We have many questions from the audience. Some questions were answered by you during the lecture, and then one person who did the question, that was Gustavo. He realized that his question were answered by you during the lecture, but we have many other questions that I will address to you. But before that, I would like to say, to comment something, that right now in Brazil, we are, the Brazilian Patent Trademark Office is doing a great job related to dealing with the backlog, and also dealing with new guidelines in many fields of patents. In the past it was biotech, and right now we had opened by the Brazilian Patent Trademark Office a public consultation related to the computer implemented inventions that is directly connected with AI. And I noticed that we have a specific paragraph in the computer implemented inventions suggested guidelines by the PTO, that Brazilian PTO, that are now in a public consultation. That I will do a free translation of this paragraph that says that artificial intelligence, it's the paragraph 13 of the page 4 of the guidelines suggested by the Brazilian Patent Trademark Office. Artificial intelligence techniques, including the tools as machine learning and deep learning, between others, applicable to technical problems, may be considered as an invention. However, though such techniques by themselves are considered only mathematic methods, if they are considered only mathematic methods, they, as such, they are not acceptable unless they are applicable to a specific technical problem, and that we can have some technical effects as a result. It seems pretty much like the other technologies that we face, new technologies that we were used to face in the beginning of the computer implemented inventions. And it seems that we can have just a kind of adjustment when we talk about artificial intelligence. And the main point of that, and maybe if you want to comment something about it, it was already stressed by your lecture. But if you want to comment about the way that in Brazil we see is pretty much similar to the European view of the problem solution approach, a little bit different than the US approach. And if you want to talk a little bit about the similarity of the approach of the computer implemented inventions when we are talking about artificial intelligence, and I'm trying right now to connect one of the questions that is from the patent attorney and patent engineer Luis Alberto, and he asks if for AI protection by patent, the descriptive report must emphasize his object as a management process. Is it right? It's another question from Professor Luis, the patent engineer and patent attorney Luis Alberto, and I believe that is related with the enablement and writing description when we have in some artificial intelligence cases a black box, a so-called black box. But in my point of view, this is pretty much solved with when you have already the state of art and you compare with the state of art. If the state of art already disclosed that, okay. If not, you have to explain, and then you have to make that possible for enablement. But if you can, maybe you can address some thoughts related to this new guidelines that we are in a public consultation in Brazil. Of course, you cannot have the whole guidelines. I just quote one part that is related to artificial intelligence. And also, if you want to talk about this concern pointed by the patent engineer, Luis Alberto.
Okay, thank you. Just now, you talked about the new guideline in Brazil. The principle is quite similar to the Chinese principle. Actually, the former software-related invention or computer software implemented invention, our regulation and the patent examination guideline of the Chinese Intellectual Property Office also have such kind of principle. So quite similar. We also use the European style regulation and a little bit or something different from the US style. So that means the Brazil style is very close with us. That is first comment. And secondly, just now you talk about another question from a lawyer about the things black box. Black box is quite a difficult technical issue because before the technical was finished or some result was produced out, we do not need whether it is a dangerous process. So if in this stage the patent examiner already decide, oh, it is dangerous, so cannot be protected, it's too early. But if already granted as patent and already implemented by some companies or by some persons, and a dangerous result already happened, it's too late. So that needs our examiner in patent office have very clear the technical background and more knowledge about AI. So now we are just organize interdiscipline research group, combine the IP or patent experts as well as the AI experts in our university. A team come from the School of Artificial Intelligence, so by several professors and PhD students, and also we have a team from our school as patent experts together to do research in deep research. They give some in-depth technical solution example. So we discuss whether that is dangerous, whether that should be protected. So in this way, we can gradually go in depth. But if only researched by the patent expert, still not enough, because we do not know so in detail about AI technologies. But only the AI colleagues, they just consider about the aesthetic things, not so about related to the patent law. So maybe in the future, we can also do international cooperation in this field. Combine the experts like you, my dear friend Milton, as Brazilian patent expert, and also collect some AI expert from your country. Thank you.
Wonderful, wonderful. Thank you very much, Professor Yu. And I was amazed with the way that you separate the weak stage of artificial intelligence and the strong stage of artificial intelligence. And it is really a nice separation, because then it's easier to understand that we are not in a really weak stage, but we are in the beginning of the AI problems related to the protection or as intellectual property. And at the same time, we can see the new developments will increase the challenges, and we must be prepared for this strong phase of AI. So I really enjoy your presentation related to this methodological separation. Thank you very much for that, and I will start to use that as well, because I think it's really enlightening about the way that we should look into the AI technologies and AI creations for artistic works as well.
Yes.
We have another questions, Professor Yu, and one of them I think it's really interesting, because it compares with the 19th century slave inventions to talk about, to understand a little bit the situation when we talk about, I think this question was made by Yusel Yilmaz, and I think the meaning of that is that as in the 19th century, the slaves had really limited rights. And nowadays, the artificial intelligence, they also have limited rights. So I think that would be combined with your separation about weak or beginning of the AI technologies, and a second moment of strong AI technologies, then the way we deal with that. It seems like, as I learned from your presentation, in the future we will have to, and I understand in the same way, we will have to consider authorship of an AI creation, even if we have to create a sui generis legislation, or if we have to adjust the legislations to the patent law and the copyright law. If you want to have more comments related with that, please, you are welcome as well.
Okay, thank you. So that is a good question. Actually, nowadays in current weak AI stage, we need to grant patent right and copyright to the owner of the AI. So it is mainly for promote continual innovation, continual creation. So this time, nowadays, the right granted to the owner of AI. So, and AI itself has relative less right, just for the copyright, the ownership, okay? But in the future, because the AI creation are more independently, so almost without the support and the participant of mankind, that is so-called strong AI stage. Principally or theoretically, the system should grant the patent right and copyright to the AI itself. However, in that time, as I suggested in my presentation, we should accept the public property solution. That means although this right should be granted to the AI itself, but that belongs to public. Everyone can use it. So the AI itself actually just have the right of mental right. That means just a name. So patentee belongs to you, okay, and the copyright belongs to you, but everyone can use it. So that is could be a good solution. Otherwise, everything is protected, almost cannot suitably implemented. That is contrary to the original purpose of the legislation.
Perfect. Thank you very much, Professor Yu. It's really good to know the future is not as dark as many people says that is dark. So we can solve it, and it's another challenge for the intellectual property field. But we will deal with that like we had in the past with the biotech patents as well. How to protect them and to avoid to have ownership on the human being, and we're gonna have the same similar challenges in the future related to AI technologies. Thank you very much. We had another question that is related. You already answered as well because it's related to the Chinese PTO is dealing with the analysis of the technologies related with the artificial intelligence, but it's one of the questions. I think it's from some patent examiner related to can we think of using artificial intelligence for patent examination in the future? How would that change the perception of inventive step? It's a good question, and I maybe it's from the patent examiner because they didn't identify itself, but or maybe another scholar. I'm not sure. I will ask for the one who made the question, if possible, could identify himself or herself. I don't know if you have something to add to that related to AI for the patent examination in the future.
Very good. Actually, nowadays, in many patent offices in different countries, AI has already used to support the mankind examiner to do patent examination. So because they are quick, more exact, and sometimes more reliable, and to support the human examiner. That is already in practice. However, whether in the future AI could be the independent examiner, if so, whether there is a so-called higher standard for examination, because AI can search almost everything in the world and select many so-called exact technical solution, which the human being examiner cannot or difficult to find out. So in this situation, maybe new invention will more difficult to be patented. So that is related to the future standard for patent examination, especially the novelty and inventive steps. So will be more difficult, but that could be in the future strong AI stage. That means the AI will be the independent examiner, okay, without support or guidance of the human being examiner. That is also a very important aspect, need to do further research. That's a good topic. So I think the colleague who asked this question, I also highly encourage him or her to do such kind of research in the future. We can also do the cooperation.
Great, great. Thank you very much, Professor Yu.
Thank you.
And we had, let me see, I think we already catch all the questions. And we have a mention from Professor Ana Gorini da Veiga. She's from the University of Science and Research in Porto Alegre here, and she said, great presentation, thanks a lot. And we have some other comments, good comments on your presentation. Thank you very much, Professor Yu. And and I would like to say that it was a real great pleasure to have. Just a minute, we have another one. Oh yeah, we had some connection problems during one of the answers, but I think now it's solved. And sorry about that. And I'm sorry for the audience. In the middle of one of the answers, we had some connection problems, but in the rest of the presentation was just perfect.
Thank you.
And I think we are going to our end. If you want to do your final remarks before we close this webinar, and I would like to say to everybody that is watching this webinar that Professor Yu was really kind to accept this invitation, because he has another conference right now that he must plan with the German. It's a German conference, right? Or
actually organized by two colleagues from Spain and Italy.
Oh, and sorry.
The audience come from many European countries.
Okay. The audience from many European countries. Perfect. And
I think the holder for this section is the so-called Director of Patent Division of WIPO. So he will charge the session, and two scholars will deliver presentation. The first is me. Another one come from Queen Mary University in London. Okay.
Oh, wonderful. And please feel free to do your final remarks. And if you want to invite people for this your new conference, please feel free to do that.
Thank you so much. And it is also my great pleasure to be invited by you, my dear friend Milton, and also thank you the support of Kelly and your wonderful colleagues. And I can feel, I have a strong feeling that the audience are quite active, and the question asked by them are with high quality, so which can also put our discussion into detail. And I think this webinar of today is a successful one, and that is a good beginning for our future cooperation, even in such kind of COVID-19 situation. Although we cannot sit together and see each other face to face, but through such kind of online discussion and webinar is also very helpful for our discussion in not only academic side, but also in the future cooperation in many different aspects. I'm looking forward to visit you after the epidemic in your beautiful country again, because I already visited your beautiful country 2 times in 2010 and 2011, but already long time. So in the future, I also want to invite you again to visit our university. And as I already told you 2 days ago, I would like to invite you, Milton, to deliver online lecture to our PhD students. Because now I'm just in the business trip. After I return to Wuhan, I will send you an email for invitation. Thank you.
Thank you very much, Professor Yu. I'm honored with this invitation, and I'm really happy with the possibility of learn from your lecture. Thank you very much for that, and I'll be honored to also participate with your learn from your PhD students and share some thoughts about the way that we see the patent law and intellectual property law here in Brazil, and try to learn more from China. And as I told you before, I admire really much the Chinese way of development in the last 20 years, and the Chinese culture, and it's really an honor to learn from you and from your thoughts. Thank you very much. And,
let's learn from each other, and also combine together to fight the COVID-19. And finally, wish all of you, your colleagues and your family and yourself, and Kelly, keep fit.
Right.
Thank you. Thank you.
Thank you.
I would like to thank you very much, Professor Yu, and also to the audience and questions addressed during this webinar. I hope that the Professor Yu lecture was as instructive and enlightening to you all as it was for me. I wish to you all a wonderful weekend, and I hope to see you all in the next 2 lectures from the perspectives of the Europe and the United States scholars. Thank you very much. Have a great weekend. Have a great weekend, Professor Yu, and hope to see you again in person as soon as we solve this issue related to the COVID-19, and we can share some thoughts in person. But meanwhile, let's keep doing that online.
Thank you so much, and the best wish to our audience. Have a wonderful weekend to you. Thank you.
Thank you. You too. Bye-bye.
Bye-bye.